hearing, so I don't know why I can't reach her. But you know, the judges are bad if you're not ready on time, so I just want to make sure she's okay. Thank you so much. Thank you.
Okay. Can you guys hear me okay?
Judge Hoffman, good afternoon.
Good afternoon. All right, we're here on, I think our first hearing. I think this will be shorter, actually. Is everyone here on Banowitz versus Foster?
Yes.
Good afternoon, Your Honor. Yes.
Okay. All right. Let's go ahead and go on the record. Let's go on the record on DC 208033, Banowitz versus Foster. Counsel and parties make your appearances.
Good afternoon, Your Honor. Stephen Davis here on behalf of the plaintiff, Leon Banowitz.
And Robert Foster here on behalf of Robert and Aaron Foster.
All right, let's get started.
Your Honor, we've had a bit of a change in circumstances. We have executed a settlement agreement with Mr. Foster that was executed earlier today. He has certain obligations that we need to work out. If it resolves, I think it will take care of the need for the court's intervention. However, we've had this conversation before. I know this is a reset from the last hearing. However, the circumstances are a little different this time. So what I request of the court is if we can get a reset to allow us to finalize the settlement terms and hopefully not have to come back in front of you again.
Do you want to just pass the hearing or do you want an actual reset?
I'd like a reset if possible. If not, I can contact the court and get that.
When are you thinking?
I'd like, if the court has availability in like 2 weeks, that would be ideal because I think we can get it done in 2 weeks.
I'm a little confused, Counselor, on the documents that have been sent and forwarded and executed on our behalf, why we would require another reset hearing in 2 weeks.
Well,
I mean,
the judgment has been fulfilled, the money's been impounded, so I'm confused on why we need to bother the court with reappearing.
Not all of the money has been. You have a payment obligation that exists outside of the writ. Your Honor, there's been a writ of garnishment served. It gets most of the judgment, but not all of it. So Mr. Foster has an obligation to pay the remaining balance that exists outside of that garnishment. And if he doesn't do so, then we have to come back. So
right, understand. So just so the court's aware, as soon as there is in excess of $30,000 encumbered above and beyond the garnishment today, and so as soon as those funds are released, counsel's firm can receive the wire transfer. I put that in the body of the email with the attached settlement agreement. So it's a simple process. Release the funds.
Well, the bank says there are $127,000 and the judgment's over $130,000. So there's a remaining balance, Judge, that has to be paid by Mr. Foster. That's according to the bank's attorney.
There's in excess of $160,000 in the bank, Your Honor. I'm not sure how that's anyway.
I think what he's doing, and this is not unusual, is this is kind of a placeholder hearing. So if everything works out between now and then we won't need to have the hearing, and Mr. Davis will contact us to cancel it. And if we do need to have the hearing, we will. Is that kind of what you're doing, Mr. Davis?
Yes, Your Honor.
All right. How does the 20th, May 20th at 10 o'clock sound for the placeholder hearing?
That works for me.
2 weeks from today, is that correct?
Mm-hmm.
Yep, that's fine.
It'll be
I don't
on.
expect it. I don't expect to see you again, Judge, but
Okay.
we'll
All
we'll put it on there.
all right. Ron, did you get that? Ron, did you get that?
Yes, Judge, I got it. May
Okay.
20th.
So it's on the Banowitz case and it'll be at 10 o'clock on May 20th. All right, guys. Good luck. I hope it all works out and you have a great rest of your day. Okay.
Thank you, Judge.
Thank you.
Okay. Let's go on the record now. On sorry, my computer's going slow. Miss Tremaine, if you want to announce the case name and cause number.
Sure. We've got Dallas County Hospital District, DBA Parkland Hospital versus Jivan Goldwire et al. Case number DC-23-01996. And I think we're here on defendants, no evidence, and traditional motion for summary judgment.
All right. And you represent the defendant?
I represent, for this motion, defendants Balfour, Brewer, Brazio, Files, Greenwood, Heinz, Nguyen, Patel, Tran, Uehara, and Williams. And my co-counsel, Karina Sanchez-Peralta, represents Shelby Reeves, defendant.
Okay. And Mr. Turek, are you there representing Dallas County Hospital District?
Yes, Your Honor. Good afternoon. Douglas Turek for Parkland.
All right. Let's get started. And actually, before we get started, Ms. Tremaine, you sent me a binder that had, I think, just the defendant's briefing. Did plaintiff ever send a binder over?
Our binder had their briefing. It just, we didn't print off their cases and highlight them for them. And my understanding is that, Doug, I think you were going to send your own binder for that.
Yes, Your Honor. We were there about 4:32 on Friday, so we missed Friday. But I believe my understanding is that it was delivered this morning at 8
Okay.
to your chambers. So you do have that binder.
All right, great. Thank you so much, guys. Why don't we proceed?
Sure. Do you want to hear from us first since it was our motion?
Yes, of course.
Okay. So basically we had filed, if you recall, you had already ruled that the liquidated damages contract was illegal, but that Parkland could still pursue a claim for actual damages. So this motion is just about that particular claim for actual damages. And we filed a motion that basically said, you don't have any evidence of actual damages, and that's our no evidence motion. And then as a backup argument to say, even if you did have that evidence, we still have the fundamental problem that the contract is illegal under the FLSA and the Texas Business and Commerce Code. Now, the FLSA piece of it goes particularly to the nature of the damages that they are seeking, which originally, if you recall, the discussion was around the training costs. Now they have shifted and said, okay, no, the damages we're seeking are replacement costs. So, the idea that because these nurses left, we had to hire new nurses of some form or another to replace them. And that cost us money. Now, there's a number of evidentiary and legal problems with that argument. And that's honestly, I think the best place to start would probably be our reply brief that sort of addresses their problems here. And that is, number one, they have 2 affidavits from 2 witnesses. And essentially what they say is, well, we couldn't really figure out exactly what we did to replace any of these nurses. But here's some methods that we use to replace nurses. And if we used these methods, here's what we think it would have cost us. But nobody can actually say that any of that actually happened. It is pure speculation. And that's, we also filed a separate motion to strike those witness affidavits on that grounds, among several others. But perhaps, that's really sort of a sufficiency of the evidence question, right? Is have they produced enough evidence to show that any damages actually occurred, or if they did, that they were caused by these nurses' departures? But separate from that, I think perhaps an easier issue for the court to base its ruling on would be the fact that replacement cost damages are consequential damages. And you cannot recover consequential damages on a breach of contract claim unless you have evidence that the parties contemplated those damages at the time of contracting. Parkland has not submitted any evidence that either party contemplated replacement costs at the time of contracting. And in fact, everything they have filed suggests the exact opposite of that the only thing they contemplated at the time is what it says in the contract, which is the costs of the training. There's no evidence that any breaching party was ever informed of the possibility of replacement cost damages. And if you can't prove that the parties contemplated those replacement costs at the time of contracting, then you cannot recover them as consequential damages. They haven't even tried to submit evidence on that particular point. That's setting aside, again, the fact that the evidence they did submit is pure hypothetical conjecture. They never say, yes, we definitely did this to replace these nurses. And in fact, their own witnesses say we were struggling with vacancies. So we have no idea whether or when any particular nurse was replaced. They can't tell you what method was used to replace any particular nurse or what it cost. All they can say is, here's two possible methods we could have used. And if we used those, here's a range of costs. They completely ignore other methods for replacement that they have brought up earlier in this case that presumably would not have resulted in damages. They just picked the two most expensive possible ones and said, well, maybe it was $7,000, maybe it was $450,000. We don't know, but here's our range. And by the way, they still haven't had a Rule 47 statement saying what they are actually seeking to recover. It doesn't, we still don't have updated disclosures saying, here's what we're seeking. All we have is saying, well, there's this like incredibly vast range of damages that possibly maybe occurred. And so somehow that's enough to prove that we did in fact incur them. Even if the court were inclined to let that slide as evidence, we still have a fundamental legality problem. And it's interesting, if you look at the case law we submitted on replacement cost damages, it's all typically in the context of construction contracts or property damage, right? You're not going to find a lot of case law on replacement cost damages in the context of an employer-employee relationship. And there's a reason for that, because passing overhead costs on to your employees is illegal. Under the FLSA, you cannot have your employees kick back costs that don't directly benefit the employee. So the only thing you can have them kick back are things like, lodging, meals, portable credentials. There are cases specifically talking about in the training context where if you give them, like, let's say some type of certification or a degree that they can take with them, so it's to the employee's benefit, that's something that you can have them kick back a reimbursement for. You can't have your employees kick back reimbursements for your overhead cost of doing it.
So there are cases where employees have had to reimburse employers for the cost of training. Is that what you're saying?
There are, and if you look at the Ameriflight case that I gave you a copy of, the recent decision.
Why don't you share screen that case?
Let me pull that up.
And before we get it, is there any news on the status of the appeal from the other case?
Our reply brief is due, I think, next week, very soon here. And so presumably within a couple of months, I don't know, after that, we might find out who's assigned to the case and what the oral argument schedule is going to be. But I will note that in that appeal, we're not arguing about the FLSA issue. It's solely on liquidated damages and Texas Business and Commerce Code. That appeal also does not address the actual damages question because that was never argued or reached in that case. So even if that decision comes down, it's not going to affect the no evidence issue that we have before us today.
Mr. Turk, let me ask you this. You know, I'm kind of, as I've made it clear a number of times, I'm trying to hold off making a final decision in this case to allow that appeal to work itself forward, because I kind of felt like it's not worth it to have two appeals on two different sides. But since we now have new issues, this actual damages issue, would it make sense for me to go ahead and just rule on everything? You can take it up so that everything can be ruled on at once, or do you want to talk? Are you handling the appeal, or do you have appellate counsel who's doing that?
I am working with an appellate counsel on that, Your Honor. But I think the response to your question is I don't think that the actual damages no evidence motion has is something that the court should grant, because we do have more than the evidence.
I'm not saying it's. I'm not really asking the bigger question, which is,
Right.
I've been holding off doing a final decision on all of this case to allow the other appeal to go forward, since the appeal of this case, no matter how I ruled, I guess if I grant the motion, it would go up. If I deny the motion, then it would not, you wouldn't be able to take it up anyway. So I guess think about it at the end if you want me to go ahead and, you know, I'm trying to be as efficient as possible here so you can get a resolution on as many issues as possible, as quickly as possible. So anyway, just think about it, Mr. Turek. Go ahead, Mr. Tremaine.
Sure. Were you wanting me to screen share the Fredericks case?
Yeah, let me enable that real quick.
Yeah, I was gonna say, I don't see it.
Go ahead.
And just, you know, full disclosure, the Fredericks versus Amerifly, I am counsel for the class of plaintiffs in that case as well. So that's
Okay.
one of my cases. I'm still not, oh, there it is. Share screen. Okay. So this is the Ameriflight opinion. This came out just a month or two ago, and this is involving cargo pilots under a trap agreement. Same basic idea, right? We're going to train you, and therefore you have to work for us for 2 or 3 years. And if you leave before then, you have to pay us $20,000. Same basic concepts that we have in this case. The procedural posture is different. This is a class action that the plaintiffs are the pilots, not the employer. So unlike here, where we have the employer suing the ex-nurses, we have the opposite procedural posture in the Ameriflight case. In this case, these are people who actually did pay the repayment penalty fee, and now we are seeking to recoup it, saying that it was paid illegally under the FLSA as well as other statutes. So what I appreciate about this opinion is the court does a very thorough job of dissecting this FLSA issue and explaining why sometimes it is allowed and sometimes it is not allowed. And the employer tried to have our case dismissed, saying that the FLSA does not apply to these agreements. The court soundly rejected that and said, no, the FLSA does apply. And it goes through and he explains that the difference between the cases like Perez and I think the other one was, let me find it, Heater. The difference between these, where the court said, yes, you can have to reimburse for training costs, is that in these cases, they got something in exchange for their training. They got a portable credential or a degree that they could take with them forward into their career and use them at other employers. So because that was a benefit that was directly conferred on the employees, the employer was allowed to seek reimbursement for those costs. And the court explains that that's different from what we have here, where in this case and in the Parkland case, there is no allegation from the employer that this was for the employee's benefit, right? And so that's why the case we have here is different from other ones where the training repayment is allowed. There is no allegation in this case that the training was primarily for the benefit of the employees. And even if they did make that allegation, they can't support it under the law, because under the law, the benefit of the employee is only going to be held up if you can show that they got something portable. some type of certificate or credential or degree that they can take with them. It does not cover basic employee training. That's something that is for the benefit of the employer, and you cannot charge those costs to an employee under the FLSA. Judge Starr also discusses this concept of what actually counts as a kickback, because Ameriflight, like Parkland in this case, made the argument of like, well, it's not a kickback because we didn't withhold it from them. Rather, we have just sued them, and that's somehow different. But Judge Starr dissects that issue as well and says, no, that is not what the statute says. It does not limit it to paycheck withholdings. And it's the only timing issue is just that's handled by the statute of limitations. So this is covered as a kickback, and you can only do it if it's for the employee's benefit. So we bring this case to your attention simply because it's not just a single sentence like, yes, it's okay, or no, it's not, but he does a very thorough job of explaining how the FLSA applies in this context. Parkland's response is, well, that case doesn't really matter because it was, a motion to dismiss, and the judge said there were fact issues. So I do want to address that argument because I think it's important. The reason the judge said there were fact issues is because this was a 12B6 motion to dismiss on the pleadings. Okay, this was not a summary judgment. So he only sort of went over basically the legal issues. Does the statute apply to this situation? And he said that it does. But then he said, look, I can't decide this on the pleadings. I need to actually see the contracts at issue and what payments were made and things like that. So we are not at the procedural stage in this case that we are in the Parkland case. The Parkland case, there has been evidence exchange. We are on a no evidence motion for summary judgment. So it is procedurally ripe for the court to be looking at this as an evidentiary issue, which was not the case in Ameriflight. So that's, I don't know, do you have any questions about the case, or is there something specific you want to see in there?
So what was the ultimate finding by Judge Starr?
So the ultimate find is that he denied Ameriflight's motion to dismiss.
Okay.
The case goes forward. Right now,
I mean, does this really support you in this particular, because what Starr is saying is that there's a fact issue, right? That's why he denies the motion to dismiss.
That's because Judge Starr did not have a copy of the contracts in front of him. He only had the pleadings. And he said, I'm not going to rule on the pleadings. But what he did say is kind of give us a very good preview of how he would rule, because he dissects the FLSA issue very thoroughly and sort of explains like, yes, it does apply here. And, our opinion is he gave a very clear preview of how he's going to rule in the case, but we just aren't at that stage procedurally. So we bring this case to your attention because this question of whether the FLSA could apply to a trap agreement, there is not a lot of case law on it. There are a few cases, and both of us have cited them, but the Ameriflight case does a very good job of going through all of the existing case law and sort of explaining why it's okay in some cases and not okay in others, and how the FLSA applies to that particular fact pattern.
Okay.
What he comes down to is this analysis, I'll highlight it for you, is this tools of the trade argument. Looking at the statute and basically saying employee training, it is more akin to tools of the trade than it is to anything else. And basically saying like, look, it is not the same as lodging and meals and facilities and things that directly benefit the employee, where you can kick back a reimbursement request to them. This is not that, is what the court is clearly saying in this case.
Okay. Anything else?
So yeah, I mean, like I said, that's just the FLSA kind of legality issue. Honestly, I think the easier call for the court here is more on the no evidence side. It's just, they haven't given any evidence of any actual damages that have actually occurred, as opposed to pure hypotheticals. And even if they had, they still didn't even try to produce any evidence that the parties contemplated replacement costs. Because remember, at this stage of the case, we aren't talking about training costs anymore. Okay. the training reimbursement liquidated damages argument is gone. That was declared illegal. So now we're only talking about actual damages. They had their opportunity to come forward and give evidence of actual damages. They didn't say anything about damages tied to training costs. That would be more of a benefit of the bargain argument, right? Like we didn't get the full value that we anticipated. They didn't make that argument. Instead, they're relying solely on replacement costs. Replacement costs are consequential damages. You cannot have consequential damages without proof that the parties contemplated it. And their own contract says nothing. It talks only about training costs, and then it says we can't ascertain what our damages are. That's why they used liquidated damages.
And Your Honor,
I say I'll let my co-counsel add anything else she wants to
Yeah,
add.
we're running out of time, unfortunately.
and Your Honor, as for the no evidence, with the breach of contract, there has to be causation between the actual damages, one that need to be identified, still have not, and the defendant that has allegedly breached that contract. Here we have, in this motion alone, at least I want to say 10 movements. For not a single movement has Parkland identified a single nurse that is someone they had to hire to replace that nurse. Now, Your Honor, specifically what they are basing their damages model on, their range is the fact that they would have to replace each nurse defendant by either utilizing nurses that were already hired, hiring experienced direct hire nurses, or 3, using contract nurses through a third-party vendor to replace that nurse. Despite the plentiful amount of pages that they attached to their briefing, they have not named a single nurse that replaced a single defendant. Not one. They have not provided a single date of hire versus the date of termination for those defendants. And what's more, Your Honor, they have not been able to, despite needing to for this, shown how the loss and the termination, the voluntary resignation of one of the nurse defendants, I'll give you my example, defendant Reeves, nurse Reeves, led to the hiring of A, a contract nurse, B, an experienced direct hire, or C, the replacement of that nurse, nurse Reeves, with somebody already on the unit. In fact, Your Honor, what they tell us is that there are already vacancies in these actual departments before the voluntary resignation of each of these defendants. And what's more, in their arguments, they state that these vacancies are not permitted, and which is why they have to calculate the damages model the way that they do. Yet these vacancies were already in place. Thus, there is no causation linking that theoretical nurse defendant hired. And Your Honor, I would also like to note that the damages model at large is meant to actually calculate the adequate staffing levels necessary for each of these units. We haven't been given a single number as to what this adequate staffing level is, not for day shift, not for night shift, not for the mid shift, not at any season, haven't been given any number as to the number of patients and what is adequate based on the number of patients. We've been given nothing but theoreticals from people that aren't the correct designated experts for these numbers.
Okay,
So Your Honor,
All right.
causation is empty.
all right. Response?
Yes, Your Honor, there's a lot of information there to respond to. I think the most important thing for me to respond to is this issue of consequential damages. The defendants try to recharacterize our damages from direct to consequential because there's a higher burden for consequential and the foreseeability issue. But the definition of direct damages is just the damages that would naturally flow from a consequence of the breach of the contract. And here, the whole point of the contracts, the agreements were for the nurse to stay at Parkland for a certain period of time for reliable staffing levels. That's what the affidavit testimony that we submitted establishes. And that they had to have these nurses. They had to have someone to replace the nurse residents that left. And so at the end of the day, the damages that we're seeking are not consequential, instead they're direct. And so the added element of foreseeability that you were told does not apply there. And Your Honor, I don't know how much time that I have here, so I don't want to rush through this, but also don't want to exceed your time.
Let me just say this, Mr. Churik. I'm going to take this under advisement anyway. So, but I want you to be able to, I want you to feel like you're getting a fair hearing. And so if there's something that you feel is really important for me to know, I will also say that I'm going to have a team of interns kind of look at this whole case, since I'm taking a bit of a risk here going directly opposite one of my colleagues who I respect to kind of see what they think about it and delve in a little deeper. So I'm not going to make a ruling today, but I also don't want you to feel like you're not getting a fair chance to make your argument. So if there's something that you feel is really important that I should know, please let me know, but just know that I'm not making a ruling today.
Okay. Thank you, Your Honor. I appreciate that. So on the issue of the consequential damages, I mean, the evidence, this is a quote from the affidavit of Mr. Enright. Because these nurses worked indirect patient care, it was not an option to leave their shifts open and uncovered by another appropriately qualified nurse, even for one shift. And so this evidence is before the court. And so when we talk about replacement of nurses, the problem is life wasn't that simple during these time periods. This is right before COVID, and a lot of it is into COVID. There may not be a replacement of the nurse from a standpoint of this job position went to another job position with a new role. They had to cover time, which is why for the damage model that we submitted, it's a basis of hours lost. If the nurses had stayed per the agreements, those hours would have been covered by the nurses that are defendants in this case. Because they left, those hours had to be covered by someone else. And so those are direct damages from this contract. There's nothing in the contract that says the only remedy that'll be sought will be repayment of the training costs. And so at the end of the day, the consequential argument doesn't match the facts of the case, and these damages should be direct damages allowed by the court. And with that said, there is sufficient evidence to get to a jury in this case. The purpose of this whole no evidence process is to see if the plaintiff has more than a scintilla of evidence. We're not required to marshal all our proof. We're not required to write down on paper every piece of trial evidence that we would submit. We only need to point out evidence that raises a fact issue on the elements here of causation and damages, and we've done that. We've submitted a range of damages for each one of the defendants, and there was an argument about we picked the highest one. Well, that's exactly opposite of what we did. We picked what we would see as the lowest damage amount and then the highest damage amount, and a jury could hear that information and they can make a decision on what the actual damages are of Parkland in this case. And so, Your Honor, on the switching to the FLSA, all the arguments that were brought up, both about the Ameriflight case and just in general, deal with recoupment of training costs. That's not what these actual damages are about. These actual damages are the cost, the impact on Parkland of the nurse defendants leaving. Not recoupment, there's a lot of terms thrown around about kickbacks and trap agreements and those kind of things. But the reality is, this is exactly what we told you in the beginning. It's a simple breach of contract case. It has simple breach of contract damages. The calculations are very, very difficult and complicated, but the case itself is very basic. And so that's why there is liquidated damages in the agreements. The court's ruled that those aren't enforceable, and that's why we're here presenting the actual damages to the court.
Okay. Anything else?
No, Your Honor, we did send you the binder, obviously, with the highlighted cases. There's ample Supreme Court authority in there that deals with the issue of what is a direct versus a consequential damages. I would point the court to the Signature Industrial case as a good example of that one. But again, I know we're on a time issue, Your Honor, so at that point, I'll wrap it up.
All right, guys, thank you so much. I'll try to get a ruling to you within the month. You guys have a good rest of your day.
I know you're going to
Thank you,
kill
Your
me
Honor.
for asking, Your Honor, but I do we had separately filed a motion, a set of objections and motion to strike Parkland summary judgment evidence. Would you prefer for us to set that, I guess, for a separate hearing since it's technically a separate motion, or do you want to do that just on submission, or what?
Did you include that in all the briefing you submitted?
Yes, but I don't think you have a paper copy of Parkland's response because it was just filed today.
And Your Honor, it was filed as a separate motion. So
Correct.
we would ask that if the court is going to review that, and
I'll review that. If I need a hearing on it, I'll let you know.
Okay.
Is that it, Mr. Turk? Is your response contained in the binder you just sent?
It is not, because their objections and motion to strike were filed on Thursday. We had it filed this morning. I would request that if there is going to be a hearing set or a submission date, that we have some notice of that, so that we had to rush pretty quickly to get a response on file with a couple of days notice.
Okay. All right, guys, I will let you know if I need a hearing on that, and I'll take a look at it. Is there a checklist order that's been submitted on that so that I can rule on it quickly, the objections?
We had not submitted a proposed order on our end because it seems like recently it's been more the practice to have the hearing and then hear what you have to say. I know Parkland submitted a proposed order denying the motion, but it sounds like you would prefer for us to have something, checking down, so you can say yes or no as to each individual thing. And
Exactly. That's what I'd like, if you could get that to me.
Okay.
As well.
I think we can work together, I'm sure, to prepare something like that and get it submitted by today's Monday, by Wednesday. Doug, is that too soon?
Wednesday or Friday? Friday might be better.
Friday's fine.
Okay.
All right, guys, you have a great rest of your day.
All right.
Thank you, Your Honor.
Judge.
Okay, our next hearing is are both sides here on Snyder versus Clark Corporation? Anyone here on Snyder versus Clark Corporation? Anyone here on Costella versus JRD LLC?
Yes, Your Honor. Michael Gobert representing the plaintiff, Fred Costella.
Brett Levinson here for the defendant at JRD LLC, Your Honor.
Great. We have a motion for continuance.
Yes,
Yes,
Your Honor.
sir.
Is this remind me, is this agreed to or no?
Yes, sir.
Yes, agreed to, Your Honor.
All right. When do you guys want to reset this to?
It's currently set for July, and I've got an August trial setting judge in front of Judge Parker, and then I've got a big trial in October in Judge Redmond's court. So what are your thoughts, Brett? I mean, we either can, and I also have a trial in September also. If we can try to fit it in somewhere, I mean, maybe November, December, but part of me says,
How long will this case take to try, and has it been to mediation?
It has not been. Yeah, go ahead, Brett.
No, go ahead. You got it.
Yeah, it hasn't been to mediation. We've made contact with your mediator that you recommended. And we've both talked to her and we've talked about setting it, but we just served some discovery on them. They've got to serve some discovery on us. So we need to discover the case a bit. But I'm thinking, from our side, maybe a day, 2 days. And then if he needs a day or two, I mean, it's only a few day trial. It's not going to be
Not more than a week.
No.
And we submitted a DCO that we agreed to with, I believe, what was the date we submitted?
Was it January?
Yes.
Yeah, I think we had a end of January trial.
We take a look at that. My computer's a little slow.
Yeah, and the only thing on that one, Judge, is I represent some high profile athletes, and part of my job is to be at the Super Bowl every year. I know it's hard. I know it's hard work, but I always
feel terrible for you.
I always seem to be trying to maneuver around that, but I just wouldn't want to set it, like the first 2 weeks of February.
Okay. I don't see a DCO. When did you submit that? Oh, wait a minute. No.
It's part of the motion for continuance, Your Honor. Let's see here. It should be an exhibit to the motion for continuance.
I mean, yeah. And Judge, we can, I think we have the dates in there. I mean, we could do towards the, latter part of January, 15th to the 25th, somewhere in there, or the latter part of February is fine with me.
So you guys have requested January 13th. Is that a Monday or Tuesday?
That is.
It looks like that's a Monday, Your Honor.
Yeah, we always try cases on Tuesday. So, yeah, I'm happy to move that to January. Let me just double check.
January 14th is actually really good for me.
Let me see, make sure I don't have a special setting that day. I don't think I do.
Yeah, that's perfect.
And this is just a suggestion for, I know that's the way things used to be submitted as an attachment, the agreed scheduling order. It's best when your staff e-files it if it's as a separate document, because I can't sign it remotely if it's done that way, or it's much more difficult. So in the future, try to submit that as a separate document through e-filing. It'd just be easier.
Brett, I think did you file it? Do you want him to resubmit it?
No, you don't need to. Just in the future, just it'd be easier.
Yes.
Rhonda, just go ahead and print that out for me. I'll tell you, what date was that filed?
Oh, I think we've had it on file. It may have been March 11th.
Okay. So I will say January 14th. It's not a horrible date. We have 16 cases set, but it's mostly DCAD. So yeah, it's not a bad date actually.
Judge, we could do the 21st too. I don't think it'll.
No, this is actually pretty good.
Okay.
It's mostly DCAD. DCAD almost never goes to trial. In fact, it's almost all DCAD. So this is actually almost the perfect date. So yeah, you might actually get reached. But Rhonda, can you find that document they're talking about? It's just print it out and put it in my stack.
Okay, no problem.
Do you know which one we're talking about?
The motion for continuance for the Castelia case?
Yeah, but attached to it has an exhibit that's the scheduling order.
Oh, okay, exhibit with the schedule. Order, okay.
Just print it out. I really just need the scheduling order. Just print that out and put it in my stack.
Yeah, got it.
All right, guys. Is that it?
Thank you, Judge.
That's all on and thank you, Your Honor. I appreciate it.
Glad it all worked out and you have a great rest of your day, okay?
All righty, bye-bye.
Thank you, Your Honor.
Thank you. Mr. or Miss Hassan Salam, what are you here for? Miss Hassan Salam, what are you here for? I don't know. All right, well, our next hearing is actually not until 3, so we'll reconvene it's that Frenchie Adams case.
Okay, at 3 o'clock.
Yeah.
Okay. All righty, I'll be back.
All right, we'll see you guys if anything changes, I'll let you know, but I'll see you back at 3 o'clock.
Okay.